Welcome, everybody. My name is Karen Thompson. I'm the Executive Director of Ask Resource Center. Thank you for joining us today for Privacy Laws for Parents, Part 1, What You Should Know About HIPAA. I am here with Jane Hudson, who I'm going to introduce in just a second. But before we get going on that, I want to do a little bit of housekeeping with you on the GoToWebinar system. So first of all, you will see in your side panel, your menu, if you will, that you have a bunch of options of things that you can click on. Beside any one of those things, when you click the plus, you will be able to see the different components that are within each of those pieces of the panel. One of the things that's loaded for you today is a handout under the handouts component. So if you click on the plus of the handouts, you'll see a PDF of the presentation that Jane's going to be delivering with us today. Now, in order to get back out of that component, should you not want to drag and drop it right now and you want to do that a little bit later, you don't want to hit the X and you don't want to hit the minimize. Just hit the little arrow that will dock it within your panel. Actually, for me, it moved it, so you may have to move it back over to your panel. Put it in the middle of my screen. If it happens to go away on you, if you click a piece that you didn't mean to click, just go up to the options component on your main menu bar. I'm going to use my tools or my arrow. I think you can see my panel. If you can't, I apologize. But there should be options at the top: File, Options, View, and Help. And if you click Open your options and your view, you should be able to see all of the different pieces that exist within your menu pane. If something disappears on you, you can go back there and double click and you will be able to get it back. Now, I have everybody in listen-only mode right now. If you have a question, I would recommend that you type it in your questions pane. And I will know then that somebody's got a question. We can stop and do question and answer. However, we are going to wait until the end of the session to do most of the question and answer. The other thing that you can do is raise your hand. I can see all of the attendees in my view pane, so there's a little hand in your icon beside your name. And if you click on your hand, that lets me know your hand is raised. Now, if you do that, what I'll do is unmute you for you to be able to speak your question, but you have to have an enabled microphone for that to work. So that's why I'm saying you're best off if you type in the questions pane. There's also an option for a chat, but I want to alert you that the chats are public. I can see them all because I'm the organizer. So if you think you're privately chatting with somebody else during the presentation, I just want you to know that I can see it. But another option would be to perform a public chat, and that way everybody could see what you're typing if you have comments or a question that you want to make. Finally, at the end of this session, we will be going over some polls. And so you will see the slides on your screen disappear, and there will be some polls available for you to weigh in on what you think might be the case. We'll go through some scenarios at the end that way. We can't tell who's voting on what, so don't be afraid of having a wrong answer. We can just see the answers coming in. So that'll be something that we'll do that's a little more interactive at the end of the session. So, like I said, what you're here for today is Privacy Laws for Parents, what you should know about HIPAA. The Health Insurance Portability and Accountability Act, or HIPAA Privacy Rule, establishes national standards to protect individuals' medical records and other personal health information that applies to health plans, healthcare clearinghouses, and those healthcare providers that conduct certain healthcare transactions electronically. The rule requires appropriate safeguards to protect the privacy of personal health information and sets limits and conditions on the uses and disclosures that may be made of such information without patient's authorization. The rule also gives patients rights over their health information, including the right to examine and obtain a copy of their health records and to request corrections. So what does that mean for you and children with special needs? Well, that's what we're going to explore today with Jane Hudson, the Executive Director of Disability Rights Iowa. She's a graduate of the University of Toledo, and most of her law career has centered on protection and advocacy for individuals with disabilities and mental illness, especially in regard to employment. Jane has previous experience working for the Arizona Center for Law in the Public Interest, the Maricopa County District Attorney's Office, and the National Disability Rights Network in Washington, D.C. Welcome, Jane. Thanks for joining us today.
Thank you so much. I'm really excited to be giving this presentation to you because I have the basic knowledge of HIPAA, but by being a presenter here, I was really able to dig into a lot of the nuances of HIPAA to share with you. This is a two-part privacy series. Today I'm talking about the Health Insurance Portability and Accountability Act, or HIPAA, and notice that I've highlighted each of the words so that you can see where HIPAA is coming from. And next week we'll be talking about the privacy rights under the Family Education Rights and Privacy Act, or FERPA. But today is HIPAA. Just some preliminary matters. Karen Thompson introduced you, and here's her contact information. And I'm going to be giving the presentation today. Nate Kirstein, in education with our attorney, with our office, will be giving the presentation next week. We wanted to talk about the funding we have to do this. Ask Resource. Karen, can you talk about that a moment?
Sure. So we have two main federal grant resources that we used to produce this webinar today. The majority of the funding comes from the U.S. Department of Health and Human Services under the Family to Family grant. In Iowa, that project is called Family to Family Iowa, and it rests with Ask Resource Center. We also have a grant from the U.S. Department of Education, the Parent Training and Information Center grant, or some people know that project as the PTI. That rests at Ask as well, and that grant paid for my time. The rest of the funding that produced these trainings came from Family to Family.
And Disability Rights Iowa is actually funded by the Ask Resource Center under the Family to Family grant to research and present this presentation. We also use some funds from the U.S. Department of Health and Human Services, Administration on Community Living, Administration on Intellectual and Developmental Disabilities. As a lawyer, I always have to do disclaimers. And this presentation is for information purposes only. It's not for providing actual legal advice. If you need legal advice about your situation, you should contact your attorney and talk about your particular issue and problem. And finally, this webinar does not create an attorney-client relationship between Disability Rights Iowa and you. But if you do have questions, please give our intake line a call using the contact information I shared previously, and we'll try to answer your questions. Okay, so let's talk about HIPAA. Our goal is to explain who must comply with HIPAA, what information is protected by HIPAA, when authorization is needed, and when authorization is not needed. Now, HIPAA is a federal law. Congress enacted it in 1996, and then the privacy regulations for HIPAA were actually issued in 2003 by the U.S. Department of Health and Human Services. There's some really good information on the web about HIPAA, and if you want to check about your rights under HIPAA, who are covered entities and business associates under HIPAA, HIPAA enforcement highlights and frequently asked questions, this is a good first website to go to get your answers. Okay, some history about HIPAA, why Congress enacted it in 1996. One is portability. HIPAA was enacted to ensure that individuals would be able to maintain their health insurance if they lost it, basically. And reasons they could lose it are there could be a life event like a divorce where the husband had insurance and the wife didn't, or the employer reduces the work hours of someone and they no longer have benefits. And the problem was pre-existing conditions. They couldn't get new insurance. So if you remember in a lot of the congressional hearings and the State of the Union address and everything, there'd be people sitting up in the balcony who had just terrible stories about how they lost their insurance and they couldn't get it from anyone else because of a pre-existing condition. Well, that was one goal of HIPAA, to give people the opportunity to enroll in group health plans when they lost insurance. And now the Affordable Care Act, which is often known as Obamacare, even carries that further. There can be no denial because of a pre-existing condition. HIPAA, so that's the health insurance portability. Now we're going to talk about the accountability parts of HIPAA. The first thing was that HIPAA requires that electronic transmission of administrative and financial data relating to patient health information is done in the same way. Before HIPAA, everyone was sharing health information in different ways, and it was very hard to use and decipher. So HIPAA requires some consistency about how health information is recorded and shared among providers. And the thing we're really going to talk about today is ensuring the security and confidentiality of patient information and data. And that is all found in some regulations of the overall HIPAA law, which is called the HIPAA Privacy Rule. And that wasn't issued until 2003. Now, the purpose of HIPAA, think of it as a teeter-totter, is creating balancing. It's privacy of health information, so not anyone can just get your health information, but it's also to promote the flow of health information for high-quality health care and the public well-being. So, with the consistency issues, it's trying to improve the flow of information, but it's also trying to protect your privacy with some exceptions, which we'll discuss later. This is the HIPAA rule. It's a basic prohibition on the use of confidential information. And really, it's a rule for providers and insurers and what they have to do. It's not necessarily what you have to do. It's an absolute provision, and we'll discuss each of these in the subsequent slides, that a covered entity, or business associate, may not use or disclose protected health information without authorization except as permitted or required by HIPAA. And what we will do is go through each of these, and I'll explain them and try to give some examples and put it together. So the first part of HIPAA, a lot of legal words, let's break it down piece by piece in the following slides, is a covered entity or business associate. And who is required to comply with the HIPAA Privacy Rule? Only covered entities. There's a lot of misunderstanding and misinformation about HIPAA, and some people believe that everyone is required to comply with HIPAA and has this prohibition. No, it's only covered entities. For example, on Disability Rights Iowa, where I work as a law firm, we are not a covered entity under HIPAA. There are other confidentiality laws we have to follow, but HIPAA doesn't apply to us. In fact, there are only 3 types of entities that are required to comply with the HIPAA Privacy Rule. They are called covered entities under the law. And these entities are healthcare providers, which transmit information electronically, and almost all do now. Health plans, which pay for the costs of health care, and healthcare clearinghouses, which are basically go-betweens between healthcare providers and health plans. Think of it as all the people doing the coding and billing and all that between a physician and the insurance company. Here's some examples of healthcare providers covered by HIPAA, and it's regardless of size. But the criteria is they're only covered by HIPAA if they electronically share health information. There can be institutional providers like hospitals, psychiatric medical institutions for children, PMICs, residential treatment facilities, intermediate care facilities for individuals with developmental or intellectual disabilities. HIPAA also covers non-institutional providers like physicians, dentists, nurses, therapists, including mental health therapists. So that is one type of covered entity. The second is health plans are covered by HIPAA. And it's individual or group plans that provide or pay for the cost of medical care, including health, dental, vision, and prescription drug plans, health maintenance organizations, Medicare, Medicaid, Medicare Choice, managed care organizations. The 3 in Iowa are all covered by the HIPAA prohibitions and requirements. Long-term care insurers and employer-sponsored health plans, which are basically where the employer pays the claims itself rather than going through an insurance company. And here's the last of the covered entity. It's healthcare clearinghouses, and as I discussed before, it's companies that code services by physicians, for example, and send them on health plans for payment. Now, business associates of covered entities are also covered by HIPAA, and when you think of it, healthcare providers and health plans and healthcare clearinghouses all need help in doing their businesses. Examples are lawyers, accountants, information technology experts. They are also covered by HIPAA, but they must agree by contract to follow HIPAA. And the information can only be exchanged between these three covered entities and the business associate without authorization. So this is promoting the free flow of information. Here's some examples of other entities that are not covered by HIPAA. Employers, like my employer, life insurance companies, worker compensation companies, government agencies that are not funding health care, patients, families, and guardians. I mean, HIPAA really covers these three covered entities. It's not covering you releasing information to someone else. And most state agencies like Child Protective Services, food assistance agencies, employment and training programs are not covered by HIPAA. Now, I bet you're wondering about schools. Are they covered by HIPAA? The answer is no. If a school creates or maintains health information and student health records, it's covered by FERPA, that Family Education Rights and Privacy Act, not HIPAA. And there's only a chronological reason for this, really. It's that FERPA was enacted about 20 years before HIPAA. So they just decided to keep that law going. And as you'll see, there's a picture of a nurse checking a school nurse checking a young student in the school. Well, in this picture, the nurse is employed or contracted by the school. So it's FERPA coverage, not HIPAA. Now, if this nurse was employed or contracted with the family and wasn't an agent of the school, then HIPAA would come in, but that's very unusual. So think of it this way. As soon as health information goes through the school doors, it's probably covered by FERPA rather than HIPAA. Okay, so I'm going to give you a little review here. I'm sure you've heard people say, HIPAA, 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 we can't provide your records. The very first question you should ask and find out is, are you a covered entity? Are you a healthcare provider which transmits information electronically? Are you a health plan which pays the cost of healthcare? Or are you a healthcare clearinghouse which acts as a go-between between healthcare providers and health plans? If it's not a covered entity, it is not required. It doesn't have to follow the HIPAA requirements or the HIPAA prohibitions. Okay, I'm going to move on now to the second part of the privacy rule, since I've already covered a covered entity or business associate. This is the prohibition. They may not use or disclose protected health information. So, what does that mean? Okay, protected health information, which is, the abbreviation is called PHI, you may have heard that thrown around, is created or maintained by a covered entity and is individually identifiable, which means you can figure out who the information is about through initials, names, addresses, and other information. Now let's deal with that first one, information created or maintained by the covered entity. It can be information about physical or mental health conditions in the past, present, or future, treatment provided, or payment for health care, past, present, or future. Now, the covered entity doesn't have to create it itself, but if it's received it and has it, then that information is health information covered by HIPAA. Now, it can not only be information created or maintained by the covered entity, the covered entity is prohibited from sharing it if it's individually identifiable information. As I said, like the name, address, phone number, the birth date, the name of the parents, the social security number, health record numbers, photos. In fact, any other information which a person could identify or figure out who that person is, it can't be shared under HIPAA unless there's appropriate authorizations or the exceptions, which we'll discuss later. Think of it this way. The blue square there is all health information. The red circle within the square is protected health information, PHI, which is the subset of all health information. HIPAA has its prohibitions on this protected health information, the information in the red circle. Now, protected health information includes everything in any format or medium. For example, I have a picture of a doctor examining a young child and others looking over, and the doctor's having a conversation with them. That information is as much a part of HIPAA privacy protections as handwritten and electronic notes. It's in any format or any medium. It can't be shared without authorization or within a HIPAA exception. Here are some examples of what is not HIPAA-protected health information. Health information and employment records, but it may be protected under other laws. Health information in most education records. As I said before, this is protected by another confidentiality law called FERPA, which we'll discuss in part 2 of the privacy series. Or de-identified data. There's 18 specific identifiers that have to be removed for covered entities to share information without authorization or not within an exception. Okay, the third one is without authorization. So we have a covered entity, or that should be business associate, may not use or disclose protected health information without authorization. So let's discuss what authorization to disclose records is. It has to be signed and dated. And it must contain a description of the information to be used or disclosed, the name or identification of a person authorized to make the request, the name or identification of a person which covered entity is authorized to disclose, and the purpose of the authorization. And you can just say at the request of the individual. That's enough. You don't have to lay out the whole purpose. Now, this means you can't authorize just by a telephone call, and even email. You know, there are electronic signatures, but I think it's better to actually, write an email and then sign it and send it by mail or deliver it to the provider themselves. And most providers have their own authorization forms, which is fine because they've had lawyers review it to make sure it's HIPAA compliant. And so it's fine to use those forms right when you're in the office of a healthcare provider or talking to an insurer. Now, these authorizations last unless you revoke it. You literally take away the authorization. And once again, it should be in writing, signed and dated, and sent to the covered entity who already has your authorization. Once again, no telephone calls. Don't do it by email. Be sure you get something for the records in writing. If you do it by email, follow up with a signed letter. Now, there's a special case under HIPAA. It's psychotherapy notes, which are very, very protected because people don't want information about their mental health shared with others. So a general authorization is not enough. There has to be a specific written authorization needed for a provider to disclose psychotherapy notes. And often what you'll see is there's an authorization form and you're making this general authorization to allow someone to share your records with another. And then there'll be little boxes for psychotherapy notes, and those will need to be checked for you to actually, for that provider or insurer to actually share records with another. Our advocate says that schools often want to get the information about a healthcare provider so they can call them and ask questions. Well, there needs to be specific authorization for any psychotherapy notes, and really the scope should be limited. So what she does is she works out the exact questions and says, we authorize you to ask these exact questions, and sends the written questions to the provider with the authorization. Providers, these are some exceptions to the psychotherapy note rule. If it's for treatment, a covered entity which originated the notes may share them for treatment purposes. For example, a psychotherapist may share them with a nurse practitioner. And the covered entity may disclose this information for its own training, legal proceedings if they're sued for malpractice, to avert serious and imminent threat to public safety, or for health oversight agencies by a government agency. Okay, but there's some cases where you don't need authorization for a covered entity to use or disclose PHI, protected health information. And here they are. No information is required for covered entity to disclose PHI to the person themselves, who the health information is about, or a personal representative of the individual, which is described in the next slide. Here's a caveat. Just being a caregiver does not mean that the person is a personal representative. It's very defined under this law. A personal representative is basically someone under state law who has the authority to make healthcare decisions. Some examples are, it could be the parent of a minor child. Now, foster parents, only if state law gives authority to make healthcare decisions. And I checked in Iowa, state law does not give foster parents the authority to make healthcare decisions unless there's a court order allowing them to do it. A parent who can make healthcare decisions under a custody decree. So if there's a custody decree and the father is allowed to make healthcare decisions and the mother not, the father is the personal representative. A guardian, if legal authority to make healthcare decisions, a power of attorney for healthcare decisions, or the executor or administrator of an estate, regardless of authority to make healthcare decisions. So if someone dies, they become a personal representative and can get protected health information. Now, here's another caveat. If it's in an abuse or neglect or endangerment situation, that personal representative may not have the authority to get the protected health information. A covered entity also does not need authorization to disclose PHI, protected health information of an individual, to disclose information to families or close friends of an adult, meaning over 18 and no guardian. If the individual agrees, the individual is given an opportunity to object and does not object, or if agreement or objection are impossible, the healthcare provider decides it's in the best interest of an individual. So this is very interesting that you don't have to be a guardian necessarily to get the protected health information, but if the individual has the capacity to agree and is given the opportunity to object and does not object, the healthcare provider or insurer can share that information with a family or a close friend. But if that agreement or objection is not possible, then the treatment providers decide. Okay, a covered entity also does not need information to disclose PHI, which allows flow of information between covered entities for these purposes. For treatment purposes, like a therapist sharing information with a physician. Payment purposes, a physician sharing information with the managed care organization, or healthcare operations, a hospital sharing information with a clearinghouse for information. Note that some covered entities obtain consent even if not required to do so under HIPAA privacy rules. They just, expand it to get authorization for everything so they don't have to run into HIPAA problems. Now, a covered entity also does not need authorization to disclose PHI protected health information to emergency personnel. Just imagine if someone is in crisis, you don't want to have to wait. The emergency room doesn't want to have to wait for consent from someone to, save their lives. To law enforcement for law enforcement purposes, to healthcare oversight agencies, to public health agencies. For example, if a public health agency is collecting information on a disease, an infectious disease, they don't need authorization. And there's others explicitly specified in the HIPAA Privacy Rule. But there is a minimum necessary requirement, and this is a key protection under HIPAA. It is actually a burden on the covered entity to keep the sharing of its information to the minimum necessary. The covered entity must make reasonable efforts to use, disclose, and request only the minimum amount of protected health information needed to accomplish the intended purpose. For example, doctors and nurses in a hospital, hospitals have policies that allow the doctors and nurses to get the entire record. They don't have to just request a specific part of the health information. If it's routine, the covered entity should develop standard protocols. If it's not routine, they have to develop reasonable criteria for limiting the information. For example, if a school nurse asks for the medications the child has from the physician, the physician should only provide the minimum necessary information, what the medications are, not the entire health record. There are some exceptions to this. On the minimum necessary requirement for treatment, as I said, hospitals, doctors and nurses can get the full record. The individual or the personal representative can get the full record. If there's an authorization saying you can get the full record, that's fine. Or disclosure to Health and Human Services for complaint investigation, compliance, and enforcement. They can get the full records. But otherwise, it's really, they're only supposed to share the minimum necessary as requested.
I can see that we have a question, so I'm going to stop for a quick second and see what that question is. Minor child versus power of attorney. Is it correct that when a child turns 18, they are no longer considered as a minor child? If the child has a disability, then is age 18 the time when the power of attorney should be created so the parents have authorization to the medical information?
Yes, that's correct. There's a lot of alternatives there. Some parents even get guardianships but it has to be under state law that you have the legal authority to make healthcare decisions. And what flows from that is the power to get medical information.
Thank you very much for the question, and we're going to go ahead and go on with the presentation at this point.
Okay, there's also some other rights. I've been talking about disclosure a lot of health information, protected health information, but there are other rights under HIPAA's Privacy Rule. One is the right to inspect, review, and copy of protected health information. So the individual and the personal representative have the right to see this information. And the covered entity can charge reasonable fees for copying and postage. Now, some people say, well, what's reasonable? It's often based on fees charged by the state for copy. But ultimately, court may decide, for example, if covered entity said it's going to cost you $4,000 to get the information, you would ask a court to try to figure out what's reasonable and not reasonable. Hopefully it can be negotiated out. Things we do are, asking to bring in our own copy machine to review records, or just inspecting records and marking them with, paper clip and saying those are the ones we want to see. But with electronic records, it's often easier for them to pull up records very quickly, and that's been my experience. The individual and personal representative also have the right to amend inaccurate or incomplete information, and you should file a written request for that. And if the covered entity agrees, then they have to amend it. If they don't agree, they need to put your request in a statement objecting to it being in the file itself. Okay, now we're going to give you some examples of a young girl named Alice. And she has a mom and dad, 2 brothers, and 2 dogs. She enjoys making cakes and doing arts and crafts. She has epilepsy and an intellectual disability. She received general education in an integrated 2nd grade classroom in Walnut Elementary School. Here's a little more on Alice. She is on the Medicaid intellectual disability waiver. Her case manager works for one of the managed care organizations, and she receives health care from a general practitioner, a neurologist, a family mental health therapist, and the school nurse. And now Erin's going to do a short poll just so you can practice some of the things you learned.
I'm going to select the poll for you while you get a little bit more familiar with Alice here. And then you're going to get a chance to, I'm not quite sure why.
I can read the question.
Oh, attendees are viewing it. Yep, good.
Oh, okay.
So, go ahead and read it, though.
Okay, poll number 1 is, who is a covered entity that must comply with the HIPAA Privacy Rule? A, Alice's neurologist. B, the case manager for the managed care organization. C, the school nurse employed by the school. D, all of the above. Or E, only A and B, the neurologist and the case manager for the managed care organization.
So everybody can go ahead and vote. And it looks like 25% of you have voted already. 50% have voted. 75%. Wait just a little bit longer. Remember, we can't see who's voting. We don't know if you're the person who answered right or wrong, so don't be shy. Go ahead and vote. I'm going to give it about 15 more seconds, and then we're going to close the poll. Okay, I'm going to close that poll.
Okay, should I say the answer,
Yeah,
Karen?
go ahead.
The answer is only A and B. And I'll explain it. Alice's neurologist is a healthcare provider that's probably transmitting information electronically. The case manager for the managed care organization, well, that's a health plan, the second type of covered entity. The school nurse employed by the school is covered by FERPA, not HIPAA, because she's employed by the school, it's not employed by the parents. So it's not all of the above. It's only the neurologist and the case manager for the managed care organization, A and B.
And 100% of our folks got it correct. Good job.
Great. Okay, we only have 4 polls, so it's very short. Here's the second one. Okay, what records are protected health information under HIPAA? A, notes from Alice's therapist. B, Alice's individual education plan. And C, data from the managed care organization on the total cost of medications for children with epilepsy on the intellectual disability waiver. So you only need to choose one. Which of those records is actually covered by HIPAA as protected health information?
And your answers on your poll are a little bit shorter because we couldn't fit the whole answers in. It has a maximum number of characters. Oh, 100% of folks have voted.
Okay.
I'm going to close the poll.
The answer is A. Notes from Alice's therapist are protected health information. Alice's individual education plan is not protected health information. It's not covered by HIPAA. It's covered by FERPA, though, because it's within the school. And then the data from the managed care organization is de-identified. It's not protected health information that's individually identifiable. So that's not covered by HIPAA either.
Okay, we're going to go to poll number 3 here.
Okay, and the question is, what protected health information requires individual specific authorization to be shared? A, clinical tests, B, treatment plans, or C, psychotherapy notes?
25% have voted so far, 50%. $75%. This one's a little trickier for people.
It is. Think of it as between a general authorization and a very specific authorization for these specific records.
I'm going to give you 5 more seconds and then we're going to close the poll. Okay, we had some split answers on that one. So Jane, what's the right answer?
The answer is the psychotherapy notes. These other records can be part of a general authorization and overall authorization. And remember, it has to be the minimum necessary information shared by the provider insurer. But psychotherapy notes require you to check specifically on the box that these must be shared.
All right, and our final poll for today
is emergency medications at school. A lot of people have questions about this. And the basic situation is the school nurse wants information about the medications she should administer if Alice has a seizure at school. Under HIPAA, what medical records may the neurologist provide to the school? A, all of Alice's medical records, or B, only those records relevant to the treatment of Alice's seizures.
50% have voted so far. There's 75%. I'll give it a couple more seconds here. Okay, I'm going to close the poll.
Okay, the answer is B. under this minimum necessary rule, only those records relevant to the treatment of Alice's seizures. Now, there are some nuances to this as well. Certainly, Alice's parents can sign an authorization for all the records to be shared with the school nurse. And another possibility is the school nurse is a health provider, and if for treatment purposes, all the records can be shared. But providers should have protocols and policies in place to share only the minimum necessary records for the purpose.
I want to jump in on this point from Ask Resource Center. We get a lot of questions about this from families because the release for authorization is provided or filled out by the school. Oftentimes when there are emergency treatment needs or even some wish to look for records or look at records on the school's behalf. As a parent, if you receive the release or the authorization and it lists a general release of information back and forth to the healthcare provider, you don't have to say yes to that release. You can have a dialogue back and forth with your school, the school nurse, or the healthcare provider to tighten up the things that you specifically want released, rather than, my only option is to share all or share nothing. So you certainly can come back to your healthcare provider and say, no, I only want, like Jane was talking about earlier, the advocate here at Disability Rights Iowa will come up with the very specific questions or the very specific pieces of information that can be shared. You can cross off general release to all school personnel and all AEA personnel. We've seen that before where it'll say release of all information back and forth with AEA in school about everything. You can cross that off and write in what it is that you are willing to share and then sign the release. Is that correct, Jane?
That's correct. That's correct. It's your release, your authorization. And the very last slide, if there's a complaint about a covered entity, a healthcare provider, or an insurance plan or insurance clearinghouse violating HIPAA, the way you do it is you have to go to the feds and file a complaint with the U.S. Department of Health and Human Services. And on the bottom here, I have the email for it. It's very easy to file a complaint online. You can also mail or fax it in, and you describe the violation, and there's a 180-day filing deadline. You have to file it within that time. And then the Office of Civil Rights of HHS will inform you that there's no more action, like it's not a covered entity, or they're not violating the privacy rule, or it's not filed in 180 days timely. Or they'll say they're going to take an action like investigate resolution. There's no private right of action. There's no right to sue under HIPAA, as the Supreme Court decision said, because there's this whole remedial scheme set up by the feds. But of course, there's voluntary compliance and corrective action and findings of violation, which the feds can impose. Also, state agencies don't enforce HIPAA, this federal law. It's the federal agencies. I have some resources for you just to get some basic question and answer information about HIPAA. Most of it is from the U.S. Department of Health and Human Services. HIPAA's been around for a while, so they have many specific issues, fact sheets on things, and you can actually just Google, like minimum necessary and HIPAA, and it will take you to specific fact sheets on that. And as I said before, these are really good resources for basic understanding of HIPAA. So we'll take questions now or comments. An evaluation reminder, please help us keep these webinars coming. We thank you for your time today. Also next week on May 25th, I believe it is, is the FERPA companion piece on privacy laws and confidentiality laws, and we hope you will attend. So I'm going to turn this over to Karen.
So if you have any questions, you can feel free to raise your hand. If you have a microphone, I will unmute you. Otherwise, you can type your questions into the questions sub-panel on the panel, the full panel itself. If you've minimized your panel in order to see the screen and you're wondering how to get it back, click on the little orange arrow at the top, and it will maximize your menu panel for you again, so you can type questions. And we'll wait for just a couple of seconds and see if anybody has any. That's just a welcome message in the chat. So far, I'm not seeing any questions. We're going to give it just another couple seconds and see if any pop up. In the meantime, I just wanted to explain that in terms of filing a complaint, Ask Resource Center with the advocates that we have on staff, the family support coordinators. If you're interested in having another set of eyes on a complaint that you're attempting to file, we'd be happy to help you. Sometimes these issues can be very emotionally charged for families, and they just want another set of eyes on the report that they're filing, making sure that it's based in fact and not in emotion, and that they're sharing the types of things that would be most relevant for them to forward on for their complaint. We can help in those ways. The people at Ask Resource Center are not attorneys, so we will not provide you legal advice. We can help you craft the information that you're trying to share. We won't share what we think is most legally relevant. We can point you to resources for those things and provide you lists of attorneys who may be able to help you. And at Disability Rights Iowa, this wouldn't fit into your focus areas. Can you talk just a minute about that?
This isn't within our focus areas, but we can provide some information for you if you need information. As I said, this online website is very easy to use and very good.
Perfect. Thank you. And we do have some questions coming up, so I'm going to click on these. Oh, it's not a question, it's a comment. It says that was very informative. Thank you. Well, you're welcome. And in the absence of any other questions, actually, I'm going to click on my answers and just move them out where I can. I'm going to try to move them out where I can see them in their entirety. There we go. Oh, for goodness sakes. Having a bit of a Yep, there are a couple more questions.
Okay.
But I'm having trouble getting them to maximize so I can see what they are. Give me just a second, folks. Sorry for the technical difficulty. Here we go. What are some warning signs that we should be aware of that may alert us a HIPAA violation is occurring?
Okay. Well, the one that jumps to mind is that a psychotherapist is sharing information with your school without your specific authorization. Another is that someone is sending all the records, and I'm going to focus on schools here, to the school when they should be doing the minimum necessary according to your authorization. The other is when you're trying to get records yourself and someone's saying, HIPAA, 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 we can't share records with you. Well, you figure out if they're a covered entity, and then they're required to share the records with you.
All right, and Melinda, I saw that you said you had a quick comment. I'm assuming that means you want unmuted. So you are now unmuted, Melinda. Do you have something you want to share? Maybe not.
Well, Karen and I talked about if you have additional questions, we can always do a Q&A, and when we archive this, put the Q&A on with it.
That sounds good. And Melinda, I can see on my control panel that you're self-muted, and so I've unmuted you on the master pane, but if you need to speak, you have to click on the little microphone beside your name to fully unmute yourself. And it looks like there's a question from Lisa. How would we know if the doctor's office is sending all of the records? Do we need to ask the school to share with us a copy of what the doctor office has shared?
Yes, but there's a procedure for doing this. Remember, once those records enter the school door, it's covered by FERPA. And then you make a request under FERPA, which we'll discuss next week, to see the records the doctor's office shared.
If you're unable to attend next week, we will record that webinar as well, and they'll be available on the Ask Resource YouTube channel. We'll also be turning them over to Disability Rights Iowa to post on their website as well. And, all right.
Oh, there she is.
I think I heard you talking, Melinda.
Oh, I'm sorry. I'm just now learning how to use this thing.
No problem.
As an advocate in our area, I'm from Texas, and what I am seeing most schools do is they're getting parents to sign general authorization for medical records. And once the school obtains those records, they generally use those records to deny or delay services for their children. Is there a legal way to combat that?
Yeah, first, don't sign a general authorization. Only an authorization for specific records related to medications or behavior or whatever. And then, you know, you have a right to get those records. And then, as Karen will point out, then it's the whole, you know, process under the Individual with Disabilities in Education Act.
Mm-hmm. Yeah, then you would start using your procedural safeguards. One of the other things that I would say is if the records are being used inappropriately in that way, or you feel that they are, of course you always have the option to file a complaint, a federal complaint regarding a HIPAA violation, but it's not really going to be, I wouldn't assume, found as a violation of HIPAA.
It's not a HIPAA.
Because they've done it right. It's just they're not using it in the proper way.
They're not using it right, and so my understanding is, and we'll discuss this more next week, is, you know, you can ask for an evaluation, a separate evaluation of the student.
Right, individual, yeah. Evaluation.
I have one quick question. If the parent signs the authorization, can they go back in writing and revoke it?
Yes. Mm-hmm. Yeah, it just needs to be signed and dated and says, I revoke the authorization. And as I said, don't do it by telephone or even by email. You know, make a copy of it and mail it or deliver it.
Now, that doesn't mean that the information that's already been received has to be destroyed. Is that correct?
No.
So if they've already got some records that they're using in a way that you feel is inappropriate, it won't necessarily help with that piece, but it will help with them not getting further information that's going to be used in an inappropriate way. And then, Melinda, it's up to, you know, those of us in the parent training and information centers and other advocates who understand special education, appropriate evaluation to work with the parent on using procedural safeguards, using the OSEP letters around not delaying and denying evaluation, those kinds of things to help provide the parent with the resources they need to empower their conversations.
Mm-hmm. So our kind of the basic theme is you're in control of what you authorize the school to get.
Thanks for the question. Any other folks want to raise hands? I'm going to check the question pane one more time, see if anything else is typed there. Don't see any other questions. I don't see any other raised hands. Oh, Lisa's typing a question again. These are great questions, you guys. Oh, it's a comment. Thank you for the great information.
Well, we sure enjoy talking with you about this. Your questions help us learn even more. Thank you.
Thank you, everybody, for your time today. We are going to go ahead and sign off of the webinar now. It will be available on our website probably as early as next week. It takes a little bit of internal finessing to edit things and get them posted and looking the way that they need to. So if you don't see it right away, that's why. Certainly, like I said, your handout is available for you there to download. So I'll leave the system up for just a little bit so that you can do that. And please, 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 at 1:30, you will receive a survey, an evaluation survey from us. Please fill that out. That's how we show the numbers on our federal grants to continue to provide services such as this to you. So please fill that out and get it back to us. Thanks, everyone. Have a great day.
Bye-bye.